Hi everybody, it's Alexei from Lexawise. Welcome back to our 100 Real Estate Exam Practice Question Series. In Part 1, we covered the first 50 common questions. Now in this video, Part 2, we're diving into the next 50 so you get the full set of exam-like practice. These real estate exam questions and answers come straight from the Lexawise database, based on what we've seen across states and what our students say has helped them the most. Here's how this works. We'll show you a question and pause to give you a moment to think. Then we'll reveal the correct answer and explain why it's right in just a few seconds. So, let's dive in. Here are 50 essential real estate exam practice questions.
Lexawise, Real Estate Exam Prep.
Let's read the first one. Out of the following statements about options, which statement is not true? A. The optionee has no rights in the land. B. The option binds the optionee to the performance. C. A lease option is a unilateral contract. D. Consideration must be given to the option or by the optionee. Take a moment to think it through. Ready? Let's check. The correct answer is B. The option binds the optionee to the performance. Why? Because in an option contract, the optionee isn't obligated to buy the property. They simply have the right to do so. The only time they're bound is after they choose to exercise the option. That's what makes it a unilateral contract. Only the option or is bound until the optionee acts. Next up, what is the type of contract between a real estate licensee and a property seller in which the seller agrees to pay the licensee a commission if they find a ready, willing, and able buyer and the licensee promises to make a reasonable effort to secure a buyer? A. Voidable contract. B. Invalid contract. C. Bilateral contract. D. Unilateral contract. Think about it for a second. Let's reveal the answer. The right answer is C. Bilateral contract. Here's why. In this case, both parties make promises. The broker agrees to use reasonable effort to find a buyer, and the seller agrees to pay a commission if the broker succeeds. That mutual obligation makes it a bilateral agreement. Let's look at this one. Out of the following events, which one is typically not considered a termination of a listing agreement? A. Death of either the selling broker or buyer. B. Foreclosure on the listed property. C. Agreement expiration upon time period. D. Disagreement between parties. Think it through. The answer is A. Death of either the selling broker or buyer. Here's why. Listing agreements are usually between the seller and the real estate firm, not a specific broker or buyer. So the death of a buyer or even an individual agent doesn't automatically terminate the agreement. Let's move on. Which type of contract involves one party agreeing to refrain from withdrawing an offer for a specified period? A. A ratification. B. A listing contract. C. Estate for years. D. An option. Take your time. And the correct answer is D. An option. An option keeps an offer open for a set time. The seller can't back out, but the buyer doesn't have to act unless they want to. That's what makes it unilateral. Here's the next one. Under what circumstances can a real estate broker acting as the seller's agent decline to present an offer to the principal? A. Never. B. When a backup offer has been accepted by the owner. C. When the broker is acting on the express instructions of the principal in his refusal. D. When the broker is acting as a free agent. Think it over. Got it? The correct answer is C. When the broker is acting on the express instructions of the principal in his refusal. A broker's job is to follow the lawful instructions of the client. If the seller says not to present an offer and it's legal to do so, the broker must comply. Now let's move on. Why would a mortgagee or beneficiary require an appraisal of a property? A. To protect the buyer from fraud. B. To ascertain the value of the property. C. To ensure that the buyer paid a fair price for the property. D. To assure the property value is sufficient to cover the loan. Take a moment to decide. And the answer is D. To assure the property value is sufficient to cover the loan. Lenders want to make sure the property is worth enough to serve as collateral in case the borrower defaults. That's the core reason behind requiring an appraisal. Let's look at this one. A finance fee charged by the lender to provide the loan is referred to as A. Prepayment penalty, B. Advance interest payment, C. Loan origination fee, D. Prepayment of mortgage insurance. What do you think? Well, the right answer is C. Loan origination fee. This is a fee the lender charges to process the loan. It's usually a percentage of the loan amount and helps cover administrative costs. Here's the next question. Mr. Rogers plans to purchase a lot for $37,000, paying $12,000 in cash and receiving a note and trust deed for the remaining balance from the seller. His intention is to build a home on the lot in 3 years. Which clause, if missing, may cause difficulties for Mr. Rogers when he starts to search for a lender to finance his construction plans? A. Acceleration clause, B. Alienation clause, C. Release clause, D. Subordination clause. Think about it. Here's the answer, D. Subordination clause. Why? Because a subordination clause allows a new lender to take priority over an existing loan. Without it, Mr. Rogers may struggle to get financing for his construction project. Let's read the next one. What statement accurately describes a second mortgage? A. A second mortgage cannot be utilized as a security instrument. B. It is not negotiable. C. A second mortgage takes precedence over a first mortgage. D. It is typically issued at a higher rate of interest. Take your time. And the answer is D. It is typically issued at a higher rate of interest. Second mortgages are riskier for lenders because they're subordinate to the first mortgage. That added risk means they usually come with higher interest rates. Here's one more. The legal title to a property under a trust deed loan is held by A. the escrow company, B. the beneficiary, C. the trustee, D. the truster. Got your answer? The correct choice is C. the trustee. In a deed of trust, the trustee holds the legal title until the borrower, trustor, pays off the loan to the lender, beneficiary. The borrower only holds equitable title during the loan term. Next up, which of the following can be recorded to create a lien? A. A notice of non-responsibility. B. A mortgage. C. An easement. D. A lease agreement. Think it over. Ready? The answer is B. A mortgage. Recording a mortgage puts the world on notice that there's a lien, a legal claim on the property as security for the loan. Let's keep the rhythm. When a real estate agent is exclusively acting as a buyer's agent, they have the authority to A. Present offers to the seller. B. Present offers to a family member of the seller. C. Present offers based upon what other buyers have offered. D. Present offers to the seller or to a seller's agent. Take a second to think. The correct answer is D. Present offers to the seller or to a seller's agent. A buyer's agent can present offers either directly to the seller or, more commonly, to the seller's listing agent. Let's keep going. In the event that a buyer previously defaulted on a written contract for purchasing a seller's real estate, the seller may still have the right to sue for damages unless there is a legal obstacle preventing them from doing so, such as A. Statute of limitations, B. Broker-attorney accord, C. Statute of frauds, D. Law of agency. Take a moment to consider. The correct answer is A. Statute of limitations. This law sets a time limit for filing lawsuits. Once that period passes, the seller can't take legal action, even if they have a valid claim. Next up, if Emily intends to sell her own property without the assistance of a real estate agent, is it necessary for her to obtain a real estate license to conduct the sale legally? A. Emily needs to obtain a real estate license to sell her own house. B. Only brokers are exempt from licensing requirements when selling their own property. C. A real estate license is not required for individuals to sell their own property. D. Emily can sell her own house without a license only if she is an attorney. This one is easy. What do you think? The correct answer is C. A real estate license is not required for individuals to sell their own property. Anyone can sell their own real estate. No license needed. Real estate license laws apply when representing others in a transaction. Here's another one. The earnest money deposit of the buyer could be A. Anything the seller considers valuable. B. A check. C. A promissory note. D. All options are correct. Take a second. The answer is D. All options are correct. Earnest money can be any form of valuable consideration, a check, a note, or something else, as long as both parties agree. Let's move on. Legally, the nature of agency relationships between brokers and principals is A. Universal agency, B. Dual agency, C. General agency, D. Specific agency. Think it through. The correct answer here is D. Specific agency. Real estate agents are typically hired for a specific task, like listing or selling a home. That limited authority defines the relationship as specific agency. Here's the next one. A broker who holds a legitimate listing for a property placed a classified ad that only includes the following information. For sale, 4-bedroom, 2-bath home with a swimming pool, asking price $170,000. Telephone 5559167. This type of advertisement will be considered an example of A. Qualified ad, B. Blind ad, C. Silent ad, D. Display ad. Take a moment to think. The answer is B. Blind ad. Why? Because the ad doesn't identify the broker or brokerage name, which is required by law. Ads like this are considered misleading and are prohibited in many states. Let's look at this one. In which year did the US Supreme Court ban all forms of racial discrimination in the sale or rental of real property? A. 1978, B. 1973, C. 1965, D. 1968. Think about it. The correct answer is 1968, so the choice here is D. That year, the Supreme Court decided Jones versus Mayer, reinforcing the Civil Rights Act of 1866 and using the 13th Amendment to uphold fair housing rights. Next question. To whom may the interest earned on an interest-bearing client's trust account not be paid directly? A. To the principal real estate broker, B. To the seller, C. To the buyer, D. To the associated broker. Got it? The answer is D. To the associated broker. Only the principal broker can handle funds and disbursements. Associated brokers and salespersons must be paid through their supervising broker, not directly from the trust account. Here's one more. What is the term used for the illegal practice of guiding minorities to areas inhabited by individuals of the same race or religion? A. Panic peddling. B. Steering. C. Blockbusting. D. Redlining. Take your time. The correct answer is B. Steering. Steering happens when an agent directs clients to or away from areas based on race, religion, or another protected class. It's a clear violation of fair housing laws. Let's keep going. A prospective buyer who belongs to a minority group requests to view homes but does not specify that they want to see properties located in an area with no minority populations. How should a licensed real estate agent determine which properties to show them? A. The licensee may select homes for showing as he would for any other prospect. B. The real estate agent is not required to show the prospective buyer homes in areas without minority populations. C. The licensee is not obligated to provide any service to the prospective buyer. D. The licensee may assume that the prospective buyer is not interested in viewing homes in areas without minority populations. Take a second to think it through. The answer is A. the licensee may select homes for showing as he would for any other prospect. That means the agent should follow the same process based on budget, preferences, and needs without making any assumptions or discriminatory decisions. Here's another one. The court has ordered that Ben Patterson's property be sold to pay off creditors. What legal document will they issue to enforce this ruling? A. A lis pendens. B. A habeas. C. An attachment. D. A writ of execution. Think about it. In this case, the correct answer is D. A writ of execution. This is a court-ordered directive that enforces a judgment by allowing a creditor to seize and sell the debtor's property to satisfy a debt. Next question. Which act mandates that reasonable accommodation be provided in public spaces for all members of the public? A. Civil Rights Act. B. Americans with Disabilities Act. C. Equal Opportunity Act. D. Fair Housing Act. Take your time. The correct answer is B. Americans with Disabilities Act. Passed in 1990, the ADA mandates that businesses and public spaces must remove physical barriers and provide equal access for people with disabilities. And now this one. What is the term used to describe a tenant's right to use a leased property? A. Leasehold estate. B. Ownership right. C. Right of lessee. D. Adverse possession. Pause for a moment. Got it? The first option is the correct answer A, leasehold estate. A leasehold estate is the legal interest a tenant holds in a property for the duration of their lease. It's a personal property right, not an ownership interest. Let's look at the next one. A neighborhood primarily inhabited by non-minorities is located adjacent to a neighborhood that has recently experienced an increase in the number of minority homeowners. A real estate salesperson begins to go door to door in the non-minority neighborhood, advising residents to sell their properties now as minorities will soon be moving in, and property values may decrease. Which of the following violations has this person committed? A. Redlining. B. Americans with Disabilities Act, ADA. Reasonable Accommodations Law. C. Steering. D. Panic peddling and or blockbusting. Take a moment to think. The correct answer is D, panic peddling and or blockbusting. This is an illegal practice that involves scaring homeowners into selling based on racial or ethnic changes in the neighborhood. It's strictly prohibited by fair housing laws. Next up, if upon receipt of a purchase under specific terms, the seller makes a counteroffer, the prospective purchaser is A. Bound by the decision of the agent. B. Relieved of his original offer. C. Forced to accept the counteroffer. D. Bound by his original offer. Got your answer? The correct choice is B. The buyer is relieved of his original offer. A counteroffer cancels the original offer. Once that happens, the buyer has no obligation to follow through with the first terms. Here's another one. What is meant by specific performance? A. A contract that has been fully performed. B. A contract where either party has the right to cancel the contract provided legal notice is given. C. When all parties of the contract have agreed. D. A legal procedure or action brought by either the buyer or the seller to enforce the terms of the contract. This is a very common question. Think it through. The answer is D. A legal procedure to enforce the terms of the contract. Specific performance forces a party to do what they agreed to do in the contract, like signing over a deed or completing a sale. Here comes another. In a situation where the heirs of an estate are selling their deceased father's house and have removed a bedroom set, a matching organ bench for a built-in organ, a television, and several renowned paintings, which item among these would be classified as real property? A. Organ bench. B. Bedroom set. C. Famous paintings. D. Television set. Take a second. A is the correct answer, organ bench. Because the organ bench was specifically designed for a built-in organ, it's considered a fixture and part of the real property. Here's the next one. When a potential buyer is not prepared to buy a property immediately and instead decides to rent it with the option to acquire it after 2 years, what type of agreement does this purchase option exemplify? A. Bilateral contract. B. Promise and exchange contract. C. Unilateral contract. D. Mutual contract. Think about it. The correct answer is C. Unilateral contract. This is an option to buy, which only obligates the seller to perform. The buyer has a choice, not a requirement, to go through with the purchase. Next up. After a contract has been rescinded and both parties have returned any exchanged considerations to one another, what event has taken place? A. Replacement. B. Cancellation. C. Restoration. D. Restitution. Take a second to decide. The right answer in this case is D. Restitution. Restitution means both parties are returned to their original positions, as if the contract never happened. It's a full reversal of the deal. Now this one. When a property is listed, we are talking about A. A contract between the buyer and the seller. B. An offer to sell. C. An option. D. A solicitation of offers to buy. Got your answer? It's D. A solicitation of offers to buy. A listing invites buyers to make offers, but it is not an offer itself. The actual offer comes from the buyer. Let's keep going. Liquidated damages are A. Any amount the parties agree on to settle a potential dispute. B. Losses suffered when liquidating a business. C. A cashier's check that is used to empty a broker's trust account. D. Paper money that has been soaked for 48 hours. Take a moment. The answer is A. Any amount the parties agree on to settle a potential dispute. In real estate, earnest money often acts as liquidated damages if a buyer breaches the contract. Let's look at this one. What is the term that refers to the legal recourse that would force a vendor to sign a deed following the conditions of a valid land installment contract? A. The equity of redemption. B. Specific performance. C. Writ of execution. D. Execution of sales. Take a second to think. The correct answer is B. Specific performance. This legal action compels the seller to follow through with the contract, especially when it comes to signing over title to the buyer. Here's the next one. What is the temporary loan based on the equity of an individual's existing property? A. Swing loan. B. Interest-only loan. C. Package loan. D. Blanket loan. Got your answer? The correct choice is A. Swing loan. Also known as a bridge loan, this helps a homeowner buy a new home before selling their current one, using existing equity as collateral. Next up, what type of loan is not backed or insured by a government organization? A. Land contract. B. Conventional loans. C. FHA loans. DVA loans. Think about it. The correct answer is B. Conventional loans. Conventional loans are private loans not insured by the government, unlike FHA, VA, or USDA loans. Here's one more. What type of loan is frequently utilized by elderly homeowners who have built up substantial equity in their homes over time? A. Reverse annuity mortgage. B. Variable or adjustable rate mortgage. C. Rollover mortgage. D. Shared appreciation mortgage. Take a second. The correct answer is A. Reverse annuity mortgage. This type of loan allows seniors to tap into their equity without making monthly payments, as long as they stay in the home. Here's the next one. The Real Estate Settlement Procedures Act, RESPA, regulations are inapplicable to A. A subordinate lien for home equity loans. B. A transaction financed solely by a purchase money mortgage taken by a seller. C. One family to four family loans. D. First lien residential mortgages. Take a moment to think. In this case, B is the correct answer. A transaction financed solely by a purchase money mortgage taken by a seller. RESPA only applies when a third-party lender is involved. If the seller finances the transaction directly, RESPA doesn't apply. Now this one. What legal mechanism could allow a trespasser to acquire ownership of real property? A. Affidavit of title. B. Easement appurtenant. C. Adverse possession. D. Easement by prescription. Got your answer? The correct choice is C. Adverse possession. If a person occupies property openly and continuously for a legally defined period without permission, they could legally take ownership. Next up, when a buyer asks his agent about the suitable form of co-ownership for him and his spouse, the agent should A. Recommend a tenancy in common. B. Not make a recommendation. C. Recommend tenancy by the entirety. D. Recommend joint and survivorship since it avoids probate. Take a second. The correct answer is B. Not make a recommendation. Why? Because advising on legal ownership forms crosses the line into the unauthorized practice of law. The buyer should consult an attorney. One more in this group. The most superior and optimal form of ownership interest in real estate is referred to as A. Fee simple absolute. B. Leasehold estate. C. Fee simple conditional. D. Life estate. Think it over. The answer is A. Fee simple absolute. This gives the owner full control over the property forever without any conditions or restrictions attached. Let's look at this one. During the course of their marriage, a husband and wife obtain a property that is registered solely in the name of one spouse. Upon divorce, the court distributes the property evenly in accordance with the jurisdictional laws of the state. Which statement best characterizes the state of ownership for the couple during the divorce proceedings? A. Constructive notice. B. Community property. C. Cooperative. D. Commingling. Take a moment. The correct answer is B. Community property. Even if titled in one spouse's name, property acquired during marriage is typically jointly owned in community property states and split evenly upon divorce. Next question. What is the term used to describe the area of a condominium project that is collectively owned by all of the unit owners and available for their use? A. Cooperative element. B. Limited common element. C. Common area. D. Community property. Think about it. The right answer is C. Common area. This includes hallways, elevators, lobbies, pools, and grounds. Everything shared and maintained by the HOA. Now this one, Thomas bought a house and used the driveway of his neighbor for 10 years. He later sold the house to Martha, who also used the same driveway for another 5 years. As a result, Martha acquired an easement A by condemnation, B in gross, C by necessity, D by prescription. Take a second. The answer is D by prescription. When someone openly and continuously uses another's land for a long period without permission, they can gain legal rights through prescriptive easement. Let's do some more. How are the subsurface rights, including mineral rights and the right to use the air above the surface of real property commonly known as? A. Avionics. B. Actuaries. C. Appurtenances. D. Appliances. Take a second. Got it? The correct answer is C. Appurtenances. These are the attached rights that run with the land, like air rights, mineral rights, and access easements. Let's keep going. If a company has not received payment for materials provided for the construction of an apartment building, they may file A. A writ of liability. B. An estoppel certificate. C. A mechanic's lien. D. A deficiency judgment. Think it over. The correct answer is C. A mechanic's lien. This lien gives contractors, suppliers, or laborers the legal right to claim the property until they're paid for improving it. Next question. The land owned by Elias and Susan, which can only be accessed through a 12-foot wide easement across Mr. Jason's property, is commonly known as the A. Beneficiary, B. Appurtenant, C. Servient tenement, D. Dominant tenement. Got your answer? The correct choice is D. Dominant tenement. That's the land that benefits from the easement. Mr. Jason's property, which must allow access, is the servient tenement. Now, this one, a landlord has instructed the property manager not to show the property to anyone older than 50 years old. This violates A. Civil Rights Act of 1866. B. None of the answers. C. Equal Housing Opportunity Act. D. Federal Fair Housing Act. Take a moment. The correct answer is option B, none of the answers. While it's unethical, age isn't protected under the Fair Housing Act, unless it's senior housing. However, age discrimination is addressed under the Equal Credit Opportunity Act, not housing laws. We are almost done. Let's see the next question. After acquiring a property, the buyer arranges for a survey and discovers that their neighbor has recently constructed a fence on their land. This situation exemplifies AN. A. Party wall. B. Appurtenance. C. Adverse possession. D. Encroachment. Think it through. The correct answer is D. Encroachment. That's when a physical structure crosses onto another person's property, usually without permission. Let's keep going. Which of the following would be classified as an encumbrance that is not a lien? A. Easement. B. IRS taxes. C. Mortgage. D. Mechanics lien. Pause for a moment and think. Got it? Option A. Easement is the right choice. A lien, which is a type of encumbrance, represents a financial claim on property. In contrast, an easement grants the right to utilize another person's land, restricting its use, but it does not involve any financial obligations. While an easement is an encumbrance, it does not fall under the category of a lien. And here is the last question. The commonly used term for the right to utilize, enjoy, possess, and transfer real property is a bill of sale. B. Building codes. C. Encumbrances. D. Bundle of rights. What do you think? Choice D. Bundle of rights is the correct answer. These rights are commonly known as the bundle of rights. And that's a wrap on some of the most common real estate exam questions. Thanks so much for sticking with us until the end. We really appreciate it. I hope this video helped you feel more prepared. If you're looking for more practice, be sure to check out our other videos. And if you're ready to take your real estate exam prep to the next level, visit us at lexawise.com. The link is in the description below. We offer practice exams with detailed explanations for every answer, just like what you saw today. In addition, we've got interactive flashcards, ebooks on summaries and math guides, educational videos and audios, all tailored to your state's specific test. Make sure to subscribe and hit the bell icon to stay updated on all our latest content. Thanks again for watching, and we'll catch you next time.